Let's dig into our first line of defense to mitigate risk, contracts. Why do we call it the first line of defense? Because it insulates the relationship to the contract terms. If something goes awry in the relationship, the contract says what each party's rights are and what their obligations are. It defines the remedies and the dispute resolution procedures to guide the parties through the problem. This is a key benefit of having written contracts. When it comes to contracts, most business leaders focus on the business terms to be sure the scope, fees, and payment obligations are correct. That's what they know best. They skim through the legalese with terms like limitation on liability, indemnification, governing law, and the like. These terms seem standard, so they sign and move on. But this is where they miss the opportunity, where they can gain a competitive advantage in contracting. That legalese defines the legal protections in the contract. Remember that contracts are intended to define rights and obligations, eliminate ambiguity, and insulate risks. For contracts to do this effectively, you must understand the risks of the relationship and really consider what could go wrong. And if it does go wrong, what's your exposure? By doing this pre-work, you obtain an advantage because your contract works for you. Let's walk through some examples of common boilerplate terms and how they can be leveraged to your benefit in your contracts. Limitation on liability. You'll see limitations on liability in many contracts to limit the financial exposure if something goes wrong. If there's a dispute, a party's claim cannot exceed a certain amount, often capped at the value of the contract. Indemnification. You'll find indemnification provisions in most contracts. Indemnification is the obligation of one party to reimburse the other party for costs or damages that come from the first party's actions. These terms are complex, and they should be tailored to the specific risks of your relationship. Dispute resolution, choice of law, and venue. These terms describe how disputes will be resolved, the how, the what, and the where. While there's no right answer for these, you'll want to consider the burden on you to litigate in a particular location and whether the selected law is favorable to you. Restrictive covenants. These are promises by a party to refrain from certain actions. Common covenants include confidentiality, non-solicitation, non-disparagement, and non-compete. These provisions should also be highly tailored to the specifics of the relationship. They are not a one-size-fits-all solution. And they're typically included for strategic reasons and should be really carefully applied. You'll want to look at every contract in light of your position in the relationship and negotiate from that standpoint. By accepting the contract terms without considering their implications to you and your business situation, you lose an opportunity to decrease your exposure and maximize the protection of your assets. Let's apply these contract tools to your business using Section 2 of the workbook.